Hey, everybody. Welcome to the Rescue Michigan live stream. It is an unusual Tuesday night stream, but I figured we'd go live tonight because, man, have I got some amazing court documents to share with you guys. But first, it is election night in New Hampshire. The polls just closed 1 hour ago, and I think most parts of New Hampshire. And there's already the race called for Trump. You can see he is up by, looks like 8.8 percentage points, which is actually better than he was doing a little while earlier in terms of the votes coming in. I don't know how that will change over the course of the evening. My suspicion is that we are not seeing absentee ballots reflected in this just yet, because many people who vote absentee may have voted for candidates that have since dropped out of the race. And so I don't think that's reflected here, because you see DeSantis and Vivek got very, very few votes. Although there could be some absentee ballots. I don't know. We'll see where this goes. I might have thought, and others might have thought, that Trump would have been beating Nikki by more than this. But we should remember that this is not only an open primary, but an open primary in which Joe Biden himself was not even on the ballot. And Democrats were totally encouraging each other to vote in the Republican primary. Because they're dishonorable people. They're shameless people. And so they would be happy to do that. So you can see, like, Nikki Haley's she did great in Hanover and in Lebanon, which this is the towns surrounding Dartmouth College. So huge liberal elite college right there. And you can see that's where Nikki Haley seems to be doing the best. But we'll see. Big population center in Manchester. And Trump has a 17-point lead there, with a little over half the votes counted. So we'll see. In Nashua, or as my cousin who lives there calls it, in Afghanistan, Trump is up by about 9 points. So that seems to be about the state average, and doing better elsewhere. So who knows? We shall see more results as they come in. So we will keep an eye on that as the night progresses. But welcome to the live stream, guys. Thank you guys for joining us. Good to see you all. We are live on all four platforms: YouTube, Facebook, Rumble, and X. So on Rumble, Mitzi Winono says hi, Adam. Jay Michaud on Facebook says every state needs to get rid of open primaries. I agree. Too bad we cannot do that in Michigan for another while yet. Dan Lawless says most Haley voters are not registered Republican. Yes, some states have partisan voter registration. I think it's slightly more than half of them. I think 26 states, it might have changed since the last time I looked, have partisan voter registration. And in some of those states, you can register as an independent and vote in either party's primary. And in some of those states, you can register as an independent and vote in neither party's primary. So the rules are different from state to state. There was a website, which I'd seen it even just very recently, called thegreenpapers.org, which used to be, when I worked in the Ron Paul presidential campaigns, it was our go-to for knowing all the different ins and outs of different state laws about how the selection process works and regulations, all that. For some reason, it is offline right now. Thegreenpapers.org was the site, but they were up like earlier this year. So my suspicion is they're just going through some kind of traffic or something. But in general, if you want to know how things work in different states, especially regarding the presidential primary process, thegreenpapers.org, that is the place to go. Anyway, we have some hot lawsuits to talk about tonight. We have a lot of things that have been going on in the Kalamazoo cases. They are now not just a single case. We'll come back at various points throughout the evening and check on the results and see how many have come in. But we have a lot to go through, legally speaking, with what's been going on in Kalamazoo. So first off, there was a lawsuit filed, I think, just yesterday. And that was, let me pull this up. This was filed, I want to say today or yesterday. Let's see. January 22nd, filed yesterday. And it is a suit from Kalamazoo County Republican Committee and Kelly Sackett in her capacity as KGOP chair against Rodney Holcomb, Carrie Lynn Eliaf, Emily Clawford, Robin Maxon, Christina Caramo, Daniel J. Hartman, James Kopus, and Secretary of State Jocelyn Benson. So it looks like Daniel Hartman will not be able to be defense counsel on this suit because he is a defendant, but we will come back to that in a minute. First, there's been some other things filed in another suit that started earlier. By the way, I see Jason says, hi, listening from Kalamazoo. Nicole Sable says, Kalamazoo checking in. Welcome, welcome. So let's go back for a moment here. This is kind of a good way to catch up on, why did it not switch the tab over? Oh yeah, it did. Okay, very good. Kind of a good way to catch up on what happened in Kalamazoo. This is their press release, so obviously it is clearly written in the opinion of Kelly Sackett, the chair. But this is kind of a good way to summarize what's been going on. On February 13th, the Kalamazoo County GOP replaced statutory members on its executive committee who resigned. Some delegates, including Sabrina Pritchett Evans and Kim Harris, complained this was illegal and created chaos at the district caucus in the state convention, voting with Ottawa County to disenfranchise Kalamazoo County delegates when they set aside Rule 9, so as to only as to Kalamazoo County. The facts are more short explaining this thing, but anyway, they removed disruptive members from their executive committee. They removed 17 delegates who they say acted against party interests. It is their opinion that as a private organization, they have the rights of First Amendment free association, and they can do what they want with control of their members. But rather than keep the conflict internal, two of the removed executive committee members and delegates, Sabrina Pritchett Evans and Kim Harris, sued the Kalamazoo GOP with funding and support from the 4th District leadership and current MIGOP leadership. That's Christina Caramo, of course, claiming that all actions taken by the Kalamazoo County GOP were illegal. The attorney in this case was not Dan Hartman, who is the former attorney for the state party. But Jason Mickelberg says Ottawa, Allegan, and Calhoun counties to be exact. Yeah, you know, this was a bad precedent when the state delegates disenfranchised the Macomb County delegation in the state convention a year or so ago. County delegates really need to understand they don't know the facts of what's going on in other counties. They really need to stop doing this garbage. And we'll talk more about that later when we see what the state committee members did to weigh in on this case on the side of wrong, which of course is the side they were on to begin with. But we'll come to that when we get there. So there was basically, and let me show, I'll pull it up. There's four counts here. I'm not going to read through all this, but one was breach of fiduciary duty, one was judicial declaration, and the other one was, up here it is, saying that essentially that the defendants violated the law when they did yada, yada, yada. So there was all these things. And then there was count 4, an action for libel and slander. So long story short, the judge in that case, Curtis Bell, and there's the attorney for the plaintiff, James Thomas, JimmyThomasLaw.com. I mean, I'm not going to read through this whole thing, so you've got so much new stuff to read through tonight. But basically, it says this is an intra-party dispute, and these are political questions. There's some spicy language in here about how the defense witness, David DeShaw, was a much better expert witness than the witness for the plaintiff, which was Joel Studebaker, who acknowledged was new to politics, having only been involved for the last few years. This somehow qualified him to serve as chief of staff as in Christina Caramo's Michigan Republican Party. Anyway, so that was kind of fun. We looked at that the other day too. But they talk about this is not justiciable, so yada, yada, yada. So the court dismisses all these claims except for one. And here's what it basically says. This is what's important down here. They go through a lot of these different cases and what the plaintiff argues. And here's the conclusion. This court is assumed to have jurisdiction, but unless divested of this presumptive jurisdiction by a statute, this court must exercise jurisdiction conferred upon it summarized in this case. And then here's the important thing. The more challenging question concerns whether there was a contractual claim based on a clear violation of the bylaws in the removal of Ms. Harris. As discussed here and above, this is not part of the plaintiff's complaint. Why is that so critical? Because that's what distinguishes this case from the case that was just filed against Christina Caramo's MIGOP, because in their case, They made clear, specific allegations as to how they upheld the bylaws and Christina Caramo violated the bylaws. Whereas in this case, they say the plaintiffs failed to allege any violations of the bylaws. So it was ordered that counts 1, 2, and 3 were dismissed, but not count 4, the defamation claim. So you would think, because the real agenda in this lawsuit was those first 3 things, is try to get them to say, we are the duly elected Kalamazoo GOP at this convention that we held. And the court said no. They still this defamation claim, which in general, folks, defamation is hard to prove in court. So, but nevertheless, the suit was not over. So let's go to something closer to the present day. So this is a motion, plaintiff's response. This is from the plaintiff's side, the people representing the people that were removed from the Kalamazoo County GOP. Attorney Jimmy Thomas. By the way, let's out of curiosity, let's see Jimmy Thomas law. Wonder who that is. Cole Sable says there's a difference between having a good attorney and knowing who they have representing them. Well, let's see. Let's see who this is they've got representing them. Hold on, I gotta just pull it up here. Let's see. Oh, that's not the window I want to use. Let's use this one. So I've got my Rumble window open, and I've got other browsers and things. So let's take a look at this here. Here we go. Jimmy Thomas Law, James A. Thomas Law Offices, advice from an expert practicing law since 1998. Okay. Services, DUI defense, criminal defense, traffic ticket defense, driving while license suspended, hit and run, racing on the highway, violation of probation. Sounds like kind of a standard criminal defense attorney. FAQ, maybe? I don't know. It's going to tell me about this guy. What are the penalties for driving while intoxicated? Florida penalties. The DUI first well, maybe he used to be a Florida attorney, came to Michigan, Tampa, Florida. Maybe his website's just been neglected. Former Tampa police officer. Jimmy knows how the system worked. His background also includes certification in traffic reconstruction and radar operations. Okay. So maybe not an expert in defamation law. Oh, well, it's fine. You don't have to be an expert in, I mean, you probably should be an expert in the field you're representing, but I guess you don't have to be. So anyway, let's get back to this. Let's get back to what we have currently happening here. So let me kind of make this bigger. Let me make this bigger. Here we go. That's much better. So what is going on here? Defendants have made a motion and amended brief for summary disposition. Plaintiff's response applies to defendant's amended motion for summary disposition as follows. Facts and argument. How long is this? This is 19 pages. Okay. Probably not going to read the whole thing right now, but let's just kind of skim this a little bit and get the gist of it. Defendants filed an amended motion for a summary disposition and a brief in support of the amended complaint, specifically count 4 defamation. Plaintiff submits this response to the motion for summary disposition. Plaintiff relies on the facts in their sworn, amended, verified complaint, exhibits, affidavits filed by plaintiffs in response to blah, 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 blah. Defense alluded to a court order saying there's 3 specific allegations. The plaintiffs advised this court will have a conflict during the trial, being that DePerno's actions as a member of the KGOP EC are both relevant and admissible. Could be, but doesn't seem to have come up just yet. Court was clear in its order that the court was clear in its order that there were enough specific facts to overcome the original motion for summary disposition as to the liable claims. The court stated further discovery would have to be finished to analyze whether the allegations can be proven. As of the date of that order, plaintiffs allege that no further discovery be taken, or no further discovery was taken by either party in the lawsuit. The plaintiffs conducted interrogatories, production, admissions. Defendants allege almost no discovery was taken, which is not true. Taking discovery depositions is a matter of strategy. At this time, the only person named is Kelly Sackett, the former GOP chair, who distributed the falsehoods and signed the propaganda. The plaintiffs' belief, that's actually correct, it's the apostrophe, that the evidence of the text messages and the public censures sent by Kelly Sackett calling the plaintiffs' members a coup d'etat rose to the level of a criminal conspiracy allegation and defamation per se, and this litigation ensued. Defamation per se. And now they have a definition of the word coup d'etat. Okay. Now they have a recitation of Michigan statute, conspiracy to commit an offense, mentioned in a legal manner. Unfortunately, folks, it's only me tonight. I wish I had some attorneys on to talk about the normalcy of using like dictionary definitions and just citing statutes like this. And well, let's see what they say here. On page 86, line 21 of the plaintiff Sabrina Pritchett Evans deposition in regard to count 4, defense counsel asked, "How have you been monetarily damaged?" The plaintiffs answered the question. It reduced standing in the community. Emma Birch says, "Matt Wilk, we need you." He couldn't make it tonight, Emma. I'm sorry. Maybe he'll weigh in the chats or something. And defense counsel followed up on page 87. "So I've looked at the discovery you produced, and I didn't see any discovery that indicated any evidence of damage within the community. Can you explain then how you've been damaged within the community?" The plaintiff responds, "That'll be decided in court." Well, that's not quite how this works. But okay, you're supposed to you have to allege the damages, unless it's per se. But we'll talk about that in a moment. So now they keep saying, okay, so here we go. So this is the important thing. The elements that must be established to sustain a defamation claim are: 1, a false and defamatory statement regarding the plaintiff; 2, a communication or unprivileged communication to a third party that is not. So first thing is, you have to say the bad thing. You have to say, so-and-so committed a coup d'etat on our county party. You have to say they made this to a third party. So someone else who would perceive you in a lesser light. Therefore, your reputation was harmed. 3, fault on the part of the publisher that amounts to least negligence. And 4, either actionability of the statement irrespective of special harm caused by the publication, or actionability of the statement regardless of special harm, otherwise known as defamation per se. Nick asked, "Did you invite DePerna to come on?" Nick, I would not have asked Matt DePerna to come on because he's the lawyer in this case. You can easily get yourself in trouble if you are a party in a suit talking about it in public, or even an attorney talking about it. I'm not saying Matt DePerna wouldn't be able to answer these questions. He probably could, but my policy is I don't bring parties on and lawyers on in cases, because they're effectively making public comments about their claims and stuff like that. It's just something you really should try to avoid. So not that I have any objection to having Matt DePerna on, but I didn't think this would be a good time to do it because we're basically reading through these suits that he himself filed, or documents that he's filed, not this one, but other ones. Anyway, so here is the important thing. If you are alleging defamation, there's basically 2 kinds. One is called defamation per se, and that is where you say something that is very specifically an allegation that someone is a criminal, something that as they say here, regardless of special harm, or you do the action, but the actionability is automatic by what it is what that means per se. For example, if I say so-and-so is a child molester, a convicted child molester, that would be defamation per se. Therefore, you don't have to allege these other elements. If I say, so-and-so is a convicted child molester, and they're not, that's automatically considered defamation. But let's say I just say, so-and-so cheats on his wife, and so-and-so is a terrible parent, or something like that. I wouldn't trust so-and-so around any kids because I've heard they have a history, things that are more vague in their nature. Now you have to prove certain specific things. First, the statement is false. Second, that the statement is made to somebody else. Third, that there is actual damage to your reputation. You can't just say he called me names, therefore I have a lawsuit against him. You have to be able to show that there's a remedy the court can provide. And then in a lot of cases, you have to prove something called actual malice, which typically the definition is like a reckless disregard for the truth of something. And that applies when you're talking about public figures. For example, and it inures to the harm of a public figure to make these harder to do. Because the idea is, if I say, for example, Donald Trump committed treason, Trump is a public figure. Whereas if I say, someone in my audience, I'm not going to name a name, but if I say so-and-so committed treason, then in that case, you don't have to prove actual malice. But in a case, and I guess treason is a bad example because that's also defamation per se, but the point being, like, making fun of politicians, you don't want a politician to be able to sue anybody. So they have this elevated standard. It's in particular to protect journalists. This is why that kind of came around. It has, over time, really swept in broader groups of people to be called public figures, and therefore are making it easier to call people names. Like arguably, I'm a public figure on my show. Just because I'm holding myself out as an organization, I'm a broadcaster, might have a small audience, but if I'm saying something on this stream, I could be considered a public figure. If someone wants to say Adam D'Angeli did yada yada, Adam D'Angeli's a racist. Well, then if I were to sue somebody for defamation, they could say, you can't show malice because I think you are, because you're a public figure. And I've heard people say this about you. That's kind of the way that all works. So the important thing about this here is that defamation per se is like your ticket out of all those other additional burdens. If you can say, what he said was automatically defamatory. But that's why they're going through all of this stuff up here to define conspiracy, coup d'etat, and you see, this is a criminal offense. This is a conspiracy. This is a criminal offense. That's what they're doing here. And so that's what this is all about. So they're going through this. You see what they're doing here. Look, they put this in bold over and over. Defamation per se, damages. Defamation per se, damages. Crime, commission of a crime, defamation per se. The inability to prove damages is not fatal to a claim, because the problem is they couldn't prove damages. So that's what they're trying to get around here. They're saying the inability to prove damages doesn't matter because it's defamation per se. And they go on about this. And again, I'm not going to read this entire thing all the way through. I'll scroll through it enough so that you guys can, if you want, pause the video and watch it, but read through it. Maybe I'll post a link somewhere in the description. But they go through this, and this is, like I said, this is like a 19-page document. And all this is to say, you shouldn't dismiss this case because there's still discovery to be done, and this is defamation per se, and there's still something that's left here. Falsely accused of having a Christian cult mentality, falsely accused of being anarchist-minded delegates with a focus on burning down the party. Matt DePerno claims that they committed they formulated a coup d'etat, et cetera, et cetera. Plaintiff Pritchett Evans is a Democrat and a disruptor. Which, by the way, if these things were said like during their court filings, those don't count. But if they were saying it during, if they're saying it during a press release, but they're only quoting the court filings, that probably still protected, because there's a level of protection you get when you're in your legal filings, basically. Anyway, so there's all this stuff. Demand for sanctions response. They want this and this and this. Long thing, 12 pages, and then there's some exhibits, which this is a case that I don't know why you'd need to print out a case citation like this, but that's what they did. Anyway, so that's what they filed. Now we have, and by the way, this was filed, let's look at the date. This was filed January 15th. All right. Now we have defendant's reply brief to the plaintiff's response to motion for summary disposition, and also a demand for sanctions. Table of contents. Oh, that's handy. Always good to make something more readable. Page. Roman numeral 2, 1, 2, 3, 4, 5. Short. 8 pages altogether. You know what judges like? Crisp, clear language that doesn't take a lot to wrap their head around. Federal cases, none. State Supreme Court cases, they have a table of citations here. Very good. Other citations. Defense reply. Demand for sanctions. Defendants, Republican Party of Kalamazoo County, et cetera, et cetera, et cetera. Submit the following for their reply and brief in response to plaintiff's response to motion for summary disposition. By the way, Patty says, where can we read the entire judgment? If you're talking about this order, I think I have it linked in the description of one of my previous videos. And I believe it's also, if you go to kgop.org or .com or whatever it is, it's on their website too. It's in their news releases. And if they're watching it in the chat, they can probably even post you a link right there. Anyway, and as for this, it hasn't been decided yet. This was just filed a few days ago. 1, defamation per se standard. Plaintiffs clearly recognize that they did not present evidence of damages, did not testify regarding damages, and have not proved any damages. Thus, they have now retreated to the newly raised argument that their defamation claim is a defamation per se claim. That's a red flag right to the judge. Hey, they're changing their story here. This is the first time we've heard this new argument. Of course, the glaring problem is they did not plead defamation per se in their complaint. Indeed, a quick word search of the entire amended verified complaint dated May 19th reveals the term defamation per se does not exist. Rather, count 4 of the amended verified complaint, and they keep saying this because they're hitting on that word amended. There was a complaint, then they changed it, and they still didn't change it to this. Nicole Sable says KGOP server is currently down. Is it really? How was there not long ago? Up kgop.org. kgop.org. It'll open up for me just now. Anyway, where was I? Oh yeah, count 4 of the amended verified complaint alleges only that defamation occurred through a press release, a text message, and a censure, which plaintiffs talk about generally but not specifically. A claim for defamation per se only exists if 1, it is properly pleaded, and 2, the alleged defamatory statement includes statement regarding chastity or criminal conduct. Indeed, and they quote, the court rules, each allegation of a pleading must be clear, concise, and direct. Complaint must state the following statement of facts without repetition, on which the pleader relies in stating the cause of action with the specific allegations necessary reasonably to inform the adverse party of the nature of the claim the adverse party is called on to defend. Nicole, try it with or without the www. Sometimes that's a thing. Under Michigan law, a plaintiff must be specific when alleging defamation, and the pleading cannot rely on general and conclusory statements, must instead specifically identify the statements alleged to be defamatory. And then there's a quotation. To properly state a claim for defamation, the plaintiff must plead precisely the statements about which he complains. Plaintiffs have failed to specifically make a claim of defamation per se. They did not even try, presumably because it never crossed their mind until they read the defendant's motion for summary disposition and realized, oops, we messed up. It should be noted that this is plaintiff's amended complaint, which they filed after defendants filed the first motion for summary disposition. Therefore, if plaintiffs truly believed they were bringing a defamation per se claim, they would have fixed it back when they filed their first amended complaint on May 19th, 2023, not now, on January 15th, 2024. Notwithstanding these glaring and obvious pleading errors, which nullifies their argument entirely, plaintiffs now retreat further into a hollow argument that the term coup d'etat somehow refers to criminal conduct. Yeah, because it couldn't possibly be something that's used colloquially. Just an Amash endorsed a coup d'etat against Trump. Peter Meyer voted for it. That, they now claim, is their defamation per se argument. So I guess I could be sued by Peter Meyer for having said that, which I've said multiple times, and I mean it. And somehow inferred from the complaint because they do not state it directly. Such an argument is without merit and frivolous. Mere statement of conclusions unsupported by allegations of fact will not suffice to state a cause of action. We talked about using legal conclusions, which you can't do. You have to say the facts and then show how this leads to the conclusion that you're asking for, which is that to declare it, defamatory. To further create the illusion of an argument, plaintiffs rely on dictionary.com to falsely state that coup d'etat means illegal. Interestingly, Merriam-Webster Dictionary applies a different definition: a sudden, decisive exercise of force in politics. American Heritage Dictionary defines coup d'etat as the sudden overthrow of a government usually by a small group of persons or previously in positions of authority. Then plaintiffs jump to MCL 750. Yada in dealing with conspiracy to commit offense or legal act in illegal manner. Of course, this all comes full circle to the fact they never pleaded defamation per se or conspiracy, or for that matter, in their amended complaint. So that's what there's basically in like one or two paragraphs. They said all this stuff they're saying here is BS. They're just pounding the table because they don't have anything they can actually rely upon. That's what they say very nicely, very concisely right there. 2, plaintiffs produced no evidence of damages, defamation per se, or conspiracy. Plaintiff's argument is further wrought with error in that they produced no evidence of damages, defamation per se, or conspiracy. They engaged in zero discovery of their own. Plaintiffs admit this in their response brief, but instead of taking responsibility for this fatal error, they blame the defendant's attorney. On page 4 of their brief, they state, defense counsel lacked asking the right question in regard to count 4, and plaintiffs will rely on defamation per se. Apparently asking the question, can you explain then how you've been damaged within the community twice is insufficient. The reality is plaintiffs, A, did not plead defamation per se. B, they did not engage in any discovery of their own. C, they did not testify that they had any damages. D, they turned over no evidence of any damages. And E, they never used the term criminal or defamation per se until the responsive brief on January 5th, 2024, which is 4 days ago. The claim was never on their radar until they got around to writing their response brief. Now they're trying to shoehorn an argument into their failing complaint. This is frivolous gamesmanship. Timing of discovery and deposition. Now here's, again, a short piece to just destroy what they took pages to do here. They said, oh, this happened here and this happened then. They give you a nice, easy to follow timeline. Timing of discovery and depositions. Plaintiffs then fall back on the refutable claim that defendant's motion for summary disposition should be denied because, following this court's August opinion, defendants did not do any further discovery since the decision, and defendants bring nothing new to the table. This is a disingenuous and false argument. That decision the plaintiffs refer to is this court's opinion in order dated August 10th, 2023. August 10th. Now, that I assume refers to this. Yep, August 10th. Which was saying these other 3 things are dismissed, but the defamation case, the discovery can continue. So, here's the timeline. Defendants, remember, the defendants are the KGOP and Matt DePerno. The plaintiffs are the Caramo people and Pritchard Evans and left their other names. So, defendants' first motion, April 28th. Plaintiffs file an amended complaint which nullifies that motion. They refile a second motion for disposition. Discovery responses received from the plaintiffs on June 16th. Depositions take place in June, July, defendant's initial disclosure. Depositions of the experts happen in July. Ken Byer, the district chair, I don't know what he has to bring to this, but he's deposed in mid-July. October 20th, 2023, discovery ends. It's obvious that literally all of the discovery occurred after defendants filed their second motion for summary disposition. Sanctions. And we're done. Plaintiffs argue sanctions should not be awarded because if the case was frivolous, then no lawyer would have gone through the vast lengths and money spent that defense counsel has taken to bring this complaint to finality. Plaintiffs then make the statement that, quote, taking a 5-hour deposition of the plaintiff and ordering a transcript on an alleged frivolous case does not sound reasonable or honest. This is retarded. This is like when Lucas Gerhard was charged with felony terror threats for making a joke about his gun to his friends, his legally owned gun. If his lawyer would have just said to him, hey, you know what? This case is BS. Don't worry about it. Turns out it doesn't work that way. First, this is not the legal standard for whether a claim is frivolous. Second, that is not the ethical standard. Lawyers do not have the luxury or discretion to advise their client that we think the case is frivolous, therefore we'll put up no defense, conduct no discovery, file no motions, and just hope the court sees it our way. You can't do that. When someone sues you, you got to treat it as seriously as a heart attack because you never know what might happen. Adopting plaintiff's view would be begging for a malpractice claim, not good lawyering. Plaintiffs made allegations of constitutional violations and slander. Those claims must be taken seriously and vigorously defended, not ignored, even if they are frivolous. Plaintiffs attempt to justify their frivolous complaint by arguing that defending such claim absolves them of liability or responsibility is, in a word, frivolous. Nicely done, Matt. Wherefore, defendants respectfully request this honorable court dismiss plaintiff's complaint with prejudice and award defendants their costs and attorney's fees and grant such other relief the court deems just and appropriate. We'll see where this goes. And this was in the courtroom of Curtis Bell. Now, here's the new lawsuit, which interestingly has that very same judge, Kalamazoo County Republican Committee, and Kelly Sackett in her capacity as KGOP chair plaintiff. You know what? Before we do this, I should have learned my lesson last time. My throat got really dry, and I had to stop streaming just because my throat was too sore. So let me take a nice sip, and let's take a moment, and let's see what's going on in New Hampshire right now, guys. Let's see. Give me just one moment to pull up the news. Here we go. Very little seems to have changed. %42% of the votes counted. Trump's lead has eroded a little bit. Looks like it's down to 7.5%. Jason Mickelborg says Trump 55 someplace else. So there you go. I happen to have the AP page up here, and it seems to be updating automatically. I can refresh it, but yeah, different news agencies will have different things. Jason, does yours say what percentage have been counted? And if so, is it bigger than 42%? Because maybe I could go over to wherever you're looking. The other thing I want to check once this is all done is overall turnout. In Iowa, Trump got, we know how Trump did in Iowa, but the overall turnout was very, very low. It was like 2/3 of what it was in 2016, which I think is a bad sign. Trump's people were very quick to point out that the weather at the Iowa caucuses was really, really, really bad. But conversely, that's the whole point of the caucuses, is that the people that show up are the ones that really care, and they're the ones that don't want to miss it. So who knows? Jason says 49% in on RSBN Live. Or is it RBS? And I don't know, but well, I don't want to pull up a video page necessarily, just because my internet connection is okay, but not wonderful, and it might stammer a little bit if I start bringing up a live video feed. Also, I don't have my headphones in, and my board doesn't work very well, so I'm not going to be able to hear what they say. But this is fine. I mean, it might be a little bit behind. Emma Birch asks, right side box, RSBN. Yeah, that's right. Emma Birch asks, is Nikki Haley's result higher or lower than expected? I would say higher than I thought, but I think the main thing that no one can really plan on is the big question is how many Democrats voted in the Republican primary. There's no easy way to know. So the lesson, I suppose, is that they might have been highly motivated to vote in the Republicans primary. I think that's the bigger takeaway. But I also think this is going to be one of the biggest states where that's going to be a problem, because you'll have, first off, there'll be some absentee ballots for people that have already dropped out of the race. You have an open primary. You have Democrats going crazy campaigning to get them to vote for Nikki. And the fact that Joe Biden is not even on the Democrat ballot is a big deal. And it was an abnormality in New Hampshire. So this is probably the best night Nikki Haley's going to have in the entire cycle. And as others have pointed out, and we've highlighted on this stream, Democrats are voting for Nikki Haley because she's a Democrat. She shares all their dearest opinions on everything. She supports open borders. She supports foreign wars. She supports all kinds of spending. She is your average neocon, which is the same as your average Democrat. Anyway, all right, let's take a look at the Kalamazoo case. The new Kalamazoo case. Looking forward to hearing what the results were from that most recent motion. This one, pull it up here. Okay, this is a brand new complaint. This is Kelly Sackett in her capacity as chair and the Kalamazoo County Republican Party. In the other suit, they were the defendants. In this suit, they're the plaintiffs. They were suing Rodney Holcomb, Harry Lynn Eliaf, Emily Crawford, Robin Maxon, Christina Caramo, Daniel J. Hartman, James Kopis, and Secretary of State Jocelyn Benson, defendants. Let's see what that's about. Now come the plaintiffs. This is an action for declaratory relief and other damages resulting from the breach of contract and fraudulent illegal actions of the individual defendants who lead a group of discontent former members of the Kalamazoo County Republican Committee and who are determined to take over the KGOP through rogue and illegal actions. This case involves claims of declaratory and injunctive relief, breach of contract, tortious interference with business relationships, obstruction of justice, election fraud, and conspiracy of the individual defendants. Uh-oh. This is serious. Plaintiffs respectfully request this honorable court grant injunction relief for all the reasons stated in this complaint. There's a motion for temporary restraining order, lots of exhibits, an accompanying brief, all of which are here and incorporated by reference. And then there's some basic things about how they have to show a controversy. Some of this is very similar to the suit that's been filed against Christina Caramo at the state level. At the heart of this case are claims of breach of contract of the KGOP bylaws as amended on February 9th, Exhibit 1, later amended on September 11th, 2023, and the bylaws of the Michigan Republican Party, Exhibit 3. The governance of the KGOP and MIGOP and the duties of their members and officers are defined by their bylaws. Bylaws are a contract among the members of the committee. They are not suggestions that can be disregarded at the convenience of any member or officer. This sounds a lot like what we read last week in the suit against Christina at the state level from the state committee members. And this sounds pretty familiar too. This case is justiciable because 1, its resolution calls upon the court to decide whether the actions described herein complied with the bylaws or breached the bylaws. 2, courts regularly deal with cases involving compliance with bylaws of private associations. See Hillsdale County Republican Executive Committee versus Darren Wisely. See also Pritchett Evans v. Republican Party of Kalamazoo et al., Kalamazoo County Circuit Court. Honorable Curtis J. Bell, the very same judge, finding that the court did not have jurisdiction to decide the dispute where the plaintiffs did not specifically plead a violation of the organization's bylaws. This is word for word what was in the complaint we read last week, which I said was an absolute stroke of genius. I don't know now anymore if it was written by Matt DiPerno or if it was written by the attorneys in the other case. But whoever did, my hat's off to you. And in this case, it's even more powerful because what it does here is it says, this is not like the Kalamazoo case that you dismissed saying we could do whatever we wanted, because the issue with that case was the plaintiffs, remember, these guys failed to plead any facts saying the bylaws were breached. Whereas in our cases, we do. Plaintiff Kelly Sackett is a duly elected chair. She is an ex officio member of the state party. Individual defendants have either directly or through acts that create a conspiracy breached the KGOP bylaws and MIGOP bylaws by holding an illegal and unauthorized convention on September 15th, 2023. Then they conspired to breach the bylaws by having MIGOP recognize a rouge band of anarchists, I suppose they mean rogue, as the official KGOP. Hey, we all make typos. On January 13th, 2024. Pursuant to MCL and the rules, MIGOP is required to hold a convention prior to the primary for purposes of electing these alternates. This will take place March 2nd, 2024 at Huntington Place, 1 Washington Boulevard, Detroit, Michigan. In addition, all counties must hold. So this is where they're going to get to about saying this needs to be decided now. This is urgent. On January 11th, KGOP properly and timely issued the official call to convention for February 15th, along with the convention rules and a cease and desist letter. Exhibit 4. We can look at Exhibit 4. Let's see what we have here. This is going to be long as the bylaws of Kalamazoo GOP and the state party. Let's get past this. Exhibit 3. Bylaws of the state committee. Yep, we don't want to read through all these again. Exhibit 4. Official call to convention. This was sent from Kelly Sackett, and there are the things. I don't see. Okay. Let's see what this is. I wonder if there's a cease and desist here. These are all the convention rules, addendum, apportionment of delegates. Okay, here we go. And we've also in a cease and desist letter, pre-suit letter. Warning, you're being sued. Rodney Holcomb. As you know, I represent the official Kalamazoo GOP. I've attached a statement of organization. I have not written to you previously because I assumed you would at some point stop claiming to be the KGOP chair after losing in court is what the assumption is there. However, on January 9th, you sent an email titled Official Call to Convention. This email is fraudulent, deceptive, and illegal. You claim that the Kalamazoo County Republican Convention will be held at 7 p.m. at Scott's Community Center. This is false and illegal. Now that you have broken the law and issued a call to convention, I am compelled to demand you cease and desist all such activity and retract your illegitimate and illegal fake call to convention. Quite frankly, your call to convention appears to be a trap to lure unsuspecting delegates in a fake convention that violates the law. These delegates should be made aware of your attempts to trick them. And this goes on for a long time, which is going to be a lot that is going to be rehashed in the lawsuit. So we can go back to that. So an actual controversy exists. The fake call to convention was sent to all delegates and will confuse and disenfranchise their vote. Some delegates will unknowingly attend the fake convention, and some delegates will correctly attend the real convention. Then there will be competing slates of delegates. One will be an illegal fake slate out of the fake convention, and the other will be the proper slate from the real KGOP convention. I like the framing here. On January 6, 2024, defendants Christina Caramo, Dan Hartman, and James Kopus were removed from their positions within MIGOP by removal, vote, and termination, yet they refused to vacate their offices of chairman, general counsel, and chief of staff, respectively. On January 13th, they breached multiple bylaw provisions by illegally recognizing the fake splinter group as the real Kalamazoo County GOP in violation of state law, using a forged and illegal document, which was then transmitted to the Secretary of State through email, wire, and mail. This illegal act constitutes fraud and obstruction of justice. January 13th, 2024 meeting also violated multiple bylaws provisions through an illegal quorum count and by setting aside specific bylaw provisions to achieve the result, which is never permitted. This complaint seeks an initial temporary restraining order and permanent injunction and declaratory relief that the fake splinter group is in fact fake, and the real KGOP is in fact real, and that the fake call to convention is unauthorized and should be disregarded because, in part, the individual defendants have breached multiple provisions of various bylaws, and Caramo, Hartman, and Kopus were removed from their positions on January 6th. I know I'm going really fast, guys, but there's a lot to read through. And probably we're going to have to even do more coverage on this later this week or this weekend with more attorneys to talk about some of these details, because you can see here there's going to be a lot of details. A lot of details about why the January 13th meeting was illegal, for example. So here are the parties. The Kalamazoo County Republican Party is a county political committee formed pursuant to state law on January 1st, 1977, and has a assigned committee ID number. The most recent amended statement of organization is attached as Exhibit 6. Kelly Sackett is a Kalamazoo County resident and the duly elected chair of the executive committee. The real KGOP, she is also an ex officio member of the state party. Rodney Halcombe is a Kalamazoo County resident and fraudulently claims to be elected chair of the KGOP executive committee. He is not a member of the real KGOP. He is not the chair of the KGOP executive committee. This is kind of funny. Carrie Lynn Elliott is a Kalamazoo County resident and fraudulently claims to be the elected vice chair of the KGOP executive committee. She is not a member of the KGOP. She is not a Kalamazoo County delegate. She is not the vice chair of the KGOP executive committee. Emily Crawford is a Kalamazoo County resident and fraudulently claims to be the elected secretary of the KGOP executive committee. She is not a member of the KGOP. She is not a Kalamazoo County delegate. She is not the secretary of the KGOP executive committee. Robin Maxon. Okay, I'm going to skip this because these are all the same things. Unauthorized, illegally elected officers of this fake splinter group, and whose actions perpetrate a fraud through misrepresentation, identity theft, election fraud, and obstruction of justice. They refer to this complaint as the fake splinter group. Christina Caramo is an Oakland County resident and fraudulently claims to be the chairman of the Michigan Republican Party State Central Committee. Well said. She was voted out of office on January 6th, 2024. She now refuses to vacate that position. In her capacity as a usurper of office, she conducts business throughout the entire state of Michigan. Daniel J. Hartman is an Emmett County resident and fraudulently claims to be the elected general counsel of the MIGOP State Committee. He was voted out of office on January 6, 2024. And you get the idea. James Kopus, same thing. Pronounced iLeaf. Okay, well, I probably won't be saying that very, very much more frequently for the rest of this suit, but there you go. Secretary of State Jocelyn Benson has the authority and has, okay, there's a typo there, but whatever. Secretary of State Jocelyn Benson has authority to accept non-fraudulent statements of organization of political committees pursuant to the Michigan Campaign Finance Act. She is included as a defendant solely for the purpose of seeking an initial temporary restraining order and permanent injunction and declaratory relief to prevent her from processing the illegal and fake documents submitted by the fake KGOP and fake MIGOP. Jurisdiction, transactions happen in Kalamazoo County, yada, yada, yada. Common allegations. I'm going to kind of skim through this because it's, well, there might be details that are important, but the gist of it you guys could probably get. KGOP has operated peacefully for many years until recently when this fake splinter group of rogue infiltrators decided it was their mission to, quote, burn down the party. The fake MIGOP officers have no authority to designate a splinter group as the official KGOP. Exhibit 8, opinion letter. Let's see what that is. Oh, wrong page of exhibits. Let's see, Exhibit 8. Vandervoort, Christ, and Fisher, PC. Legal people. And what do they say? How long is this? That's the next question. Do I want to read through all of this? Probably not. Okay, well, anyway, Matthew X. Hauser has written a lengthy opinion here. The Rouge group of citizens are not a registered political group. There's nothing in the state party bylaws that would permit it to violate MCL. Recognize this Rouge group. Third, to somehow suggest that MIGOP today could recognize a Rouge group of people who are not members or delegates of KGOP as the official county party organization because they lost a county political battle would not only erase over 150 years of history over an internal political spat, but would be also illegal. In essence, MIGOP would be dismantling the KGOP and installing its own group of Whigs. Nice. So there you go. I scrolled through this. You can probably, in the future, pause the video if you want to read through this entire thing. Can a delegate issue? Here's an important one. Can a delegate issue a call to convention? No, only the county chair can. Can a non-delegate issue a call to convention? No, only the county chair can. Can a member of the KGOP who is not in the executive? No. Only the county chairperson can issue a call to convention. Also, only at least in Kalamazoo, only the county chair can schedule a regular meeting. See Article 4 of their bylaws. So there you go. Is the September 15th convention called by Carrie Lynn Eilief legal and valid? No. Conventions under the state party or the county party's bylaws can only be called by the county chair. For this reason, the current convention called by Carrie Lynn Eilief and scheduled for September 15th is not legal or valid for the following purposes. Yada, 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 yada. Emma Birch asks, if Christina is no longer MIGP chair, will these core problems still affect the party and state committee? Well, in this case, the parties in the case are the county party, which will, yes, still be having to go. I mean, until this is done, lawsuits can take a long time and a lot of money. And this is going to affect the county party for a long time. But will it affect the state party? Well, assuming the courts recognize that Christina is no longer chair and Dan Hartman is no longer counsel, then no, the state party's clear of this because the state party is not a party of this case. Christina Caramo is, and Dan Hartman is. They'll have to pay their own lawyers. Anyway, where were we? Yeah, I'm not going to quote the bylaws, but we were somewhere around here. Okay, the Michigan Republican State Committee, governing body, does not have an office, but instead rents a UPS box at 3415 Alpine Avenue, Northwest, Box 206, Grand Rapids, Michigan. Oh, let me go back to doing it this way. That's better. Let me make this bigger too. Can I make this bigger? Why is it scrolling and not biggening it? Oh, well, sorry. I'm trying to make it bigger, but I can't. The bylaws are clear and provide for autonomy of county committees. The county committee shall adopt their own bylaws and rules of procedure. The MIGOP is specifically not affiliated with any county committee. The MIGOP shall not assert control over any county committee. Nevertheless, as stated in Article 2, the MIGOP is required to cooperate with county organizations, not work against them. And there it all is in the state party's bylaws. And of course, Christina Karama believes the rules don't apply to her. And so that's why she has been obsessed with interfering in county parties' affairs for the entire past year. So the article officers were elected, yada, yada, and there's documentation of that, et cetera, et cetera. Removal of delegates. Okay, here we go. This is the thing that Christina's people all rely on too, is they remove people. Well, here's what they say. After the election of the executive committee and officers, several members of the executive committee resigned. Some of them had run for office in the 2022 cycles, and after losing their elections, did not want to be a part of the executive committee. On February 13th, the executive committee met and voted to fill all empty seats. That's not personally what I would do in my county, but our bylaws could be different. Their customs could be different. They have a right to do what they want under their bylaws. Also, following the election of the executive committee and officers, a group of delegates and members, including Sabrina Pritchett Evans and Kim Harris, footnote, Sabrina Pritchett Evans ran against Kelly Sackett for the position of chair on December 12th, 2022, and lost. Oh, so there might be some sour grapes involved here. So rather than walk away, they started to engage in anarchist type behavior where their focus was on burning down the party, where raising money and electing Republicans was not important, but instead they desired to push a radical agenda through a cult mentality that will purify the party. And only when the party is purified will the party be able to attract the right kind of donors needed to transform the party into their image. We have a person just like that in Washington County named Samantha Strayer, who was, by the way, also wormed her way into the state party. Same exact story. Got removed from being a chair because she wanted to rule the whole party. And so he decided to try to burn the thing down, just start nothing but rumors and lies. Anyway, this goes on, and of course does nothing to help anybody. The anarchist-minded delegates and members engaged in disruptive behavior, such as 1, secretly recording meetings in violation of published KGOP rules and procedures, and 2, posting those videos on social media and disrupting meetings such a degree that business could not be conducted and police were called to remove them from the premises. That's probably coming soon to a county near you, folks. On March 1st, the KGOP Executive Committee voted to censure 4 delegates and members who had engaged in anarchist-minded activities. These were Sabrina Pritchett Evans, Kim Harris, Veronica Perro, and William Bennett. I could probably think of some people in my county who would be the ones who would be doing her bidding. Same exact stuff. Look, folks, I've gotten beat at conventions. I've been involved in the party for a long time. Kitty, say hi and say goodbye. When you get beat at convention, you leave. You come back with more delegates next time. That's how that goes. If you don't want to be involved you still want to be involved in the cause, do your own thing. I started a company called Rescue Michigan. Anyway, on March 29th, they filed a lawsuit styled Sabrina Pritchett Evans and Kimberly Harris versus Republican Party of Kalamazoo, State of Michigan, et cetera, which is, of course, before this very same judge in this very same court. The executive committee removed 17 delegates from the KGOP. These removed delegates included defendant iLeaf, Sabrina Pritchett Evans, and Kim Harris. The 17 removed delegates are the following, and there are their names. I don't know why some are highlighted and some are not, but whatever. Delegates are not elected positions. Instead, they are party positions and are subject to membership requirements of the party. Decision to remove a delegate is an internal party process that will not be disturbed by the court and is not justiciable. See our very earlier case. And by the way, folks, again, it's kind of a moot question because the reality is when you have a county convention, there is a thing called a credentials committee. And the precinct delegates at that convention will vote to adopt the credentials committee report. And they will say if they think some people should or should not be admitted as delegates. At a not too long ago state convention, the delegates at that convention removed an entire county delegation, a big county delegation in Macomb County. That can happen. Be aware. On August 10th, the court issued an opinion dismissing 3 of the 4 counts. Judges can be like, oh, yeah, I remember this. In essence, the KGOP is an independent private political organization that has the right to govern itself, control its membership, and establish rules and procedures. However, the court stated that it could have heard claims related to breach of contract, but the plaintiffs in that case did not bring a breach of contract claim. Why would that be? Maybe because they followed their bylaws and there was no claim to bring. Just saying. After the removal of these delegates and members, some of them formed a splinter group called Kalamazoo Delegates, aka Kalamazoo Precinct Delegates, aka Kalamazoo County Delegates, even though some of them were no longer delegates. On or about August 12th, this fake splinter group started sending emails to Kalamazoo County delegates claiming they were the real KGOP. This was done to harass the real GOP and hurt fundraising efforts. A fake splinter group calls a fake convention. And this goes on. This convention, they had to remove the chair and all the rest of this stuff. No request was made for a special meeting. Again, and now this is where it's the same as the other case. They're going through the bylaws and saying the bylaws don't allow this, the bylaws don't allow that, the bylaws do allow the things we did, the bylaws don't allow the things they did. Fake splinter group holds a fake convention. The fake splinter group fraudulently convinced delegates to attend their meeting through deceptive means, including sending a video through email and telling delegates to attend. Exhibit 15. And here we go. Let's see. Exhibit 15. Tyranny Unmasked. Below is an updated link for the video shown at the special convention. The link sent earlier has expired. Tyranny Unmasked at Kalamazoo, Michigan. God bless KZoo delegates. Yeah. The biggest charlatans always obsess about they're wearing their faith on their sleeve. But doesn't this rhetoric sound kind of familiar, folks? Have we heard this before? Pursuant to section 5.3, the bylaws, only the KGOP can publish the convention rules. They must be published 2 months prior. Well, anyway, I'll tell you what, guys. I'm starting to get tired. It's after 10 already. But you can see the pattern here. I'll scroll through so you guys can see the whole complaint, and you can pause the video if you want so you can read through it in more detail. But the facts are kind of obvious. This was done by the bylaws. What we did was by the bylaws. What they did was not. After the fake September convention, the fake splinter group misappropriates the KGOP name and image. Following the September 15th, 2023 illegal and fake convention, defendant Holcomb continued to send emails to delegates stating he was the GOP chair. Oh, here she is. Sabrina Pritchett on Facebook says, not true. Kelly breached the bylaws. The judge stated that. Where? Let me go back to this here. You want me to pull this up here? Because here's what it says here. The more challenging question is whether there's a contractual claim based on a clear violation of the bylaws. As discussed here and above, that's not part of the plaintiff's complaint. Whoops. Well, there you go. We'll see. We shall see what the judge says. Apparently, the judge thinks there was. Go to the judge's opinion. I've read through the entire judge's opinion. Well, anyway, you've seen this opinion. It's right here. Getting back to the complaint. What's happened here? Members removed for failure to pay dues and participate. Executive committee met, removed to remove people that failed to pay dues. Like I posted here, I would. I mean, I have scrolled through the entire thing at least twice now in this video. Okay, Hartman and Kramer were removed. We've been through this multiple times in this past week on various streams. New call to convention. Leadership. Okay, we've been through all this stuff a bunch of times. Okay, now they are contacting the Secretary of State. Hartman and Kopis. This is now, okay, this is good because this is more recent than January 13th. They held this meeting, violated the bylaws, and recognized the fake splinter group as the KGOP after being fired. So I think what they're saying is the violation of the bylaws was having the meeting. The entire meeting, start to finish, was a violation of the bylaws. On January 14th, Halcom sent an email stating his fake splinter group was now the KGOP. Let's look at these exhibits too. Let me scroll down here. So here's all these letters they sent saying they're removed. And there's a lot of them. Return of property letters that they had to send out after they were removed. Okay, so this is what they passed on the 13th, I guess. Statement on state intervention. There are 4 levels of political committees within the convention of delegates in the Republican Party nationally. the delegates, which are the building block of the Republican Party, formed through conventions, a county, district, and a state. But anyway, this goes on for a long time. It's all a bunch of legal gibberish here. You've got the quoting of Height Manis case, which is not even a landmark case at all. Again, completely wholly different case, completely different set of facts. But they say, yeah, one recent exception was when on motion, the state was required to recognize the convention of delegates from Kalamazoo County, who rescinded the grant of authority to an executive committee and county chairwoman and replaced them. We were required. Hey, at least they obeyed the judge's order. Not quite the same as what they did in Hillsdale County. Anyway, by the way, folks, if you ever see a document from someone that's changing the size of the font or the color of the font, you're talking to a crazy person. But this is apparently what the state committee passed, and according to their minutes, which I think are in here somewhere in the exhibits, passed unanimously, which is shameful. But here we go. So now they send out this email to the delegates from kzudelegates@gmail. Dear delegates, I'm pleased to inform you that as it was a momentous decision, the Michigan State Party's Central Committee, which it was not, in a decisive vote, officially recognized the newly elected executive committees, which assumed office on September 15th as the legitimate executive committee of Kalamazoo County. By the way, folks, is this here? This is where they notice the Secretary of State. Oh yeah, here's the minutes of the fake meeting on the 13th. And there's a lot of funny things in here. I'll scroll through this more slowly so you can pause the video if you want to read the whole thing. But most importantly is the simple fact that when it got time to address the issue of Kalamazoo, where is that here? Here we go. Yep, here it is. The motion passed unanimously. Every single member of the state committee that has participated in this meeting on the 13th can no longer be elected to any position of authority in any part of the Republican Party in the future, folks. Every last one of them. Know who they were in your county. Know who went to the real convention, who went to the fake one, or the real meeting and the fake meeting. These are all people who are systematically, methodically destroying the party. And maybe some of them have good intentions, but their bad judgment is disqualifying from ever being in a position where these people can be involved in the Republican Party ever again in any position of authority. Just saying. Sabrina, I'm being patient, and I'm not going to ban you just for arguing with me, but please just, if you're going to say, look at this, what about this, what about that, I'll address it, but otherwise I'm going to ignore you for the time being. Anyway, let's get back to the complaint. Letter is fraudulent because Karamo, Hartman, and Kopus have been removed from their positions. Yep, that just kind of follows from that. So here we go. Counts. Oh, here we go. Halcom obstructs justice and attempts to steal bank account by demanding access to KGOP financial records, and a message to Sackett demanding access to their financial records to access the bank account of the state party. So there you go. So count one, declaratory judgment, injunctive relief, granting injunctive relief for all this stuff, the controversy that exists, yada, yada, yada. They want a judgment in the following form. The fake call to the September convention was illegal in violation of the bylaws, did not have a quorum present. The fake call to the February convention was illegal and in violation of the bylaws. By the way, the other thing too, folks, and Sabrina, even if you had argued in your lawsuit that that some of the precinct delegates were removed improperly under the bylaws, that still doesn't make any of this other stuff go away. The KGOP official call to convention is the only proper and authorized call to convention for the only authorized February convention of Kalamazoo delegates. Kelly Sackett remains chair. Karamo, Hartman, and Kopus had no authority to recognize the fake splinter group because the bylaws and state law does not permit such action. And Karamo, Kopus, and Hartman were previously removed or fired. Secretary of State and county clerks and local clerks shall not recognize the false and fraudulent letter submitted by Hartman and Kopus on January 16th. All actions taken by the defendants are null and void and have no force or effect as a fraud on Kalamazoo delegates, the Secretary of State, and county and local clerks. All actions taken by Karamo, Hartman, and Kopus are being removed on January 6th, including not limited to any meetings they may have called or held, any actions taken. This may end up being the first forum where this is issued. Breach of contract, again, the thing that the other suit didn't get into. Tortious interference with the business relationship. Probably a more tenuous claim just because it's talking about the issues between the delegates and the county party itself and the delegates. But the idea is they're hurting their fundraising. So wherefore, because of defendants' action and conduct, plaintiffs have suffered damages in an amount of not less than $25,000 for the injuries sustained plus additional damages as may be proven to compensate them for losses and damages. Yeah, come to think of it, the people that are bad-mouthing my county party might be harming us financially. But that's a different set of facts, so I'm not suggesting that. Well, saying it might be, but who knows? I'm not a lawyer. But whoever wrote this complaint is obstruction of justice and fraud against the individual defendants. As noted above, they committed a fraud on the Secretary of State, the Kalamazoo County Clerk, and local precincts by sending notices and emails that are false and fraudulent. Committed a fraud on delegates, sending them fake notices, et cetera, et cetera, et cetera. Damages. Count 5, conspiracy and concert of actions against the individual defendants. Plaintiffs restate and incorporate as if set forth fully herein all preceding allegations contained in this complaint. The individual defendants acted tortiously. They acted pursuant to a common design at all relevant times, engaged in concerted activities to steal the county party, et cetera, et cetera, et cetera, et cetera. So there's all that. And that's the basics of the suit. But wait, there's more. Motion for a temporary restraining order. And I'm not going to read through all this stuff because it's very similar to what we've read already and very similar to the motion for TRO that we read in the suit from the state committee members against Christina before. Some more exhibits here. So more or less the same, but there is also, let's see, what have we here? To the clerk of the county of Kalamazoo, please schedule a hearing date for the following in accordance with Michigan court rules on an emergency basis as soon as possible. Irreparable harm will occur on February 15th, 2024. What's that? That's the date of the county conventions. Estimated amount of time for a hearing on this matter is 30 minutes, maybe, but there you go. This is a motion for an emergency hearing on this stuff. That's what they're saying. And then there's one more thing. The jury demand. Oh, that's just a jury demand letter. So there you go. So there you go, folks. That is what has been filed in Kalamazoo County this week. I will make sure I put a link in the description on Rumble and maybe YouTube as well to all of these documents so you can read through them yourself. But there you go. All I can say is we will see probably pretty soon where this all goes. But a lot of stuff in here. A lot of stuff. Very interesting. We will see what all happens with this very, very soon. All right, let's go back and see what's going on in New Hampshire and close down the stream. Thank you guys once again for joining me tonight. I may read through some chats too. 59% of the votes counted. Donald Trump, 53.6%. He is up by, and this is with 59% of the votes counted. So that is 8.6% of a lead. Don't see much I can tell in the patterns of the. It still looks like absentee ballots probably haven't come in just yet, but we'll see. Emma Birch asks, is there a place online you house documents for reference? Emma, I might make like my own web page or something for this because I do have some links and some descriptions. Who knows? Maybe I'll get like a lawsuit.com kind of website or something to keep them all handy. But I'll at some point I will put them all in like a folder or something. So there you go. That's where things are now. And yeah, a smaller margin than polls suggest, but that's again just because Democrats are voting in the Republican primary. On Rumble, Charlotte Cosmic says, Adam, are you saying anyone that went to the 9/15/2023 meeting can't be part of the Republican Party? No, I'm not exactly saying that, Charlotte. And actually, that was more in reference to this January 13th meeting in wherever KK had our meeting up north. And that's not the same as the convention. The convention you're talking about on 9/15, that was the pretend county convention that they had. And precinct delegates might not know what exactly to think, which is understandable. But the state committee meeting on January 13th was a meeting that by that time, every state committee member has a choice to make. Are they going to allow the Christina Caramo circus to continue in violation of the bylaws? Or are they going to support Christina? And not only support Christina, but voted unanimously to overthrow the Kalamazoo County Republican Party, having probably no set of facts to know what was really even going on in Kalamazoo. Now, I'm not saying they can't be Republicans, but I'm saying they should not be in any position of authority in the party ever again. Because even if they have good intentions, their judgment was so unforgivably bad that these are people that you need to recruit delegates to defeat them at the next county conventions. And there's people like them, folks. But the litmus test for certainly are their actions in doing things like that. Sabrina Pritchett says precinct delegates are not dumb. They are fighting for our state. Well, in my county, most of the precinct delegates don't do anything, actually. Jason Mickelborg says delegates are confused and so are constituents. Yeah, they are. That's why this has to be resolved very soon. Yeah, I mean, if you want an example, we had a state committee meeting, a state convention a year or so ago, and people having no idea what the facts were in Macomb County voted to overthrow and disenfranchise the entire Macomb County delegation. Sorry, that's bad judgment. Thomas LeDuc says Katrina is the Joe Biden of state chairs. Christina is the Joe Biden of state chairs. Yeah. There's actually others. It's not just Christina. We did a show a few weeks ago talking about this, but there's this almost identical effort going on in Nevada, in Wisconsin, to bankrupt the state party, and they're coordinating. We'll talk more about that whole effort too. We'll talk about the people acting behind the scenes, people like Mike Labadie, and who the actual deep state manipulators are here. Sabrina says the Kalamazoo delegates are smart. The ones that elected Kelly Sackett are. All right, guys, that's going to do it for us for tonight. Bethany, one more. Bethany on Rumble says the fake Kalamazoo party saying a call to convention is election interference in the presidential primary. That's a crime. I don't believe in playing the Democrats' games, guys. I don't believe in calling Democrat protests insurrections. I don't think we set a good example by doing unto others what they do unto us. I think it just makes us go further and further towards anarchy. I think you have to always, when you do the wrong thing because the wrong thing is being done to you, you just lose your moral high ground. That's all that happens. So, is it election interference? I mean, yeah, kinda, but that's not a trend you want to. This is an issue best kept as a civil action, in my humble opinion. You could make a criminal argument about this, but I think, again, Democrats persecuting Republicans is not something you want to legitimize by having Republicans who are in power persecuting Democrats either. So, all right, guys, thank you guys for tuning in. I guess we'll find out tomorrow or next week or next month or next year what the final results in New Hampshire were. But looks like it's still a pretty good night for Trump. Still would be curious to see how turnout lines up. There's what's interesting. You've got 10,000 votes for Joe Biden. No, you've got 43,000 votes for Joe Biden, basically. Here, let me put this back on the screen. 43,000 votes for Joe Biden in the Democrat side. A total of, it looks like, about 55,000 votes, 60,000 votes, something like that on the Democrat side. And you've got nearly 200,000 votes on the Republican side. That tells you there's crossover votes. You could probably even compute how many Democrats voted crossover to vote for Nikki Haley, just looking at that. So we'll see what happens. All right, guys, that will do it for us for tonight. We will probably have yet another stream during this week because there's so much going on constantly. But until then, thanks as always for all you guys do for liberty.